address the issue in Venezuela subsequently to what I had in mind, because I think it's a very important issue. But I think the panel is addressing the issue of why is the protection of foreign investments changing, if you will. And Ignacio was pointing out to some interesting issues. I'm going to go a step back and probably ask ourselves, kind of make a rhetoric question. Why, in the first instance, the countries signed into the regime of international protection of foreign investments? In the 60s, when the exit convention happened, and subsequently in the 70s, when the boom of bilateral investment treaties and free trade agreements with investment chapters was brought to the attention of policymakers. And I think if we answer that question in the way I think policymakers answer that question, they signed into the whole package because basically countries were looking for a way to finance development. Countries are in the business of development, of making the life of their people better. And one way to finance development is through foreign investments. There are other ways, loan, aids, etc., but foreign investment is one of those ways. Countries were bought into the idea that signing into the whole package of those agreements was going to be an automatic bottom, according to which once they signed that, all investments were going to fly into the country, and consequently that was going to bring jobs, technical assistance, enhance the productivity of the country, etc., etc. Now, we need to ask ourselves now, has that happened? If that has not happened, maybe that's why some countries are not so much antagonizing the system of foreign investment protection, but probably reshaping the system that maybe had some positive things, but maybe also had some flaws. I personally believe that the system was shaped for historic momentum that is no longer in place. In other words, when in the 60s, the world was so different from the world we have right now. When the idea of the exit convention was put in place, to use the words of a commentator, arbitration as a concept was a borrowed suit for the regime of foreign investment protection. But that suit probably is no longer fits the reality of what we're seeing these days. Why exit, for example, in those days was expected not to have so much cases. As a matter of fact, exit spent years without having cases. Now the average is more than 2 or probably 4 or so in a month. So that was one reason why I understand Ibrahim Shihada suggested to the former general counsel, among other people, and also Aaron Broches, etc., the idea of arbitration, because you did not have to have a permanent tribunal of people sitting there and not doing anything. You can have arbitration and then consequently ask people and set up a dispute resolution mechanism as needed. Now the time has passed, and one of the criticisms that I see in countries making to the exit system is legitimacy. Why are people that sometimes are lawyers defending investors, and then the other day are arbitrators sitting in a panel? Why? What is the legitimacy they have, for example, to question measures of economic emergency or measures of regulation or sovereign, or any other sovereign measure that the country could take in their foreign investments, such as expropriation or indirect expropriation, etc. That's one criticism, for example, that is being made. I think with reason. It's not what I hear is that it's not that countries are opposed as such to the concept of having a neutral international mechanism to settle disputes between investors and states. I think that's a great idea, and if I can elaborate on some on the reasons why I think countries are not opposed to the concept of neutral mechanism to settle disputes. you'll see that there are hints about that. So you have criticism on the side of the countries, you know, for legitimacy, in some cases also for cost, in some cases also for the length of the procedures. Even investors are, to a large extent, also questioning the fact that they claim for a specific percentages, and those that succeed are succeeding far below what they ask. There is also the criticism of the president. You see different arbitral tribunals deciding similar issues, and sometimes based on the same treaty, going in different directions. And that's a criticism that to me has teeth. Then why are countries leaving? I think, and you forgot to mention, Hernando, Nicaragua. Nicaragua is a country that has threatened to do this. And there are other countries that, although you see that happening, you see other countries, Haiti, for example, you signed the exit convention, but that's only part of the picture. While you see that within the exit scheme, you see other countries also getting into bilateral investment treaties, signing free trade agreements, and you see the usual suspects, as we would say, you know, Panama signing the free trade agreement, you know, with the investment chapter, Colombia, Peru, etc. Colombia, you know, entering into agreements with Canada as well, and Europe, etc. But there are the not so usual suspects that are also entering into bilateral investment treaties. Probably not with exit arbitration, but they are providing for protection of investors. For example, Cuba. You would say Cuba. Cuba just signed 2 or 3 years ago bilateral investment treaties with no other than the Netherlands, for example, which is paramount bilateral investment treaty with the UK. Venezuela, you know, another usual suspect. Well, Venezuela entering into bilateral investment treaties with, you would say, well, Iran, blah blah, but it entered into bilateral investment treaties with Russia, for example, which is a country that is exporting capital and is doing business in Venezuela. Now, the clause of dispute resolution mechanism did not provide for exit. It provided for Estocol and Oncitral, etc. To me personally, I think exit has very good things, and I would tell here and everywhere that move of Venezuela and other countries consenting arbitration to center different than exit is a bad move, among other things, because if countries are looking for investments, as I said before, because it's a means towards financing development, then you want to make sure that the investments you are protecting are so-called exit investments, meaning investments that promote economic development. And within exit, you have the possibility of eventually object jurisdiction to the so-called to investments that do not fit the so-called Salini criteria, for example, according to which the last criteria is economic development, meaning that the investment needs to be meaningful to economic development. That possibility you don't have under Oncitral, or you don't have under Estocol. So, just to sum up this part, my conclusion would be that I don't see countries, I don't see this as a trend. I see there are flaws in the system. I think the system needs to probably reshape. But I see different indication that even the countries that you would say are opposed to protection of foreign investment are sending different hints. And that's all, again, only a portion of the picture. You have, even in those countries, you have something that didn't happen in the 60s. And it's that those countries are not only capital importing, they're also capital exporting. You have, for example, Cemex, you know, as a multinational in Mexico, you have Odebrecht in Brazil, you have Petrobras, you have Embraer, you have Braskem in Argentina, you have PDVSA in Venezuela, etc., etc. And all these companies are doing business all around the world, including developing countries. And I believe those companies are going to put pressure on having some kind of international protection for investments. So the picture is not black and white, as I said, because even I recall that in the case of Petrobras, when there was this